first case to come before us this morning is Esposito versus Mauger. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve any time for rebuttal, please let me know when you get started. The court's read the briefs. Please keep your voice up so that we can hear you, and be muted when it is not your turn to argue. Please don't use the names of any victims or minors, as this argument is being posted on YouTube and being recorded. Like I indicated, the court has read the briefs. We are ready to proceed when you are.
Well, thank you, and good morning. It's Attorney Kevin Breen on behalf of the appellant, Nick Esposito. Given my own technical acumen with respect to Zoom and the like, I assumed the problem was on my end. So thank you for. If I may, I'd like to reserve 5 minutes at the end of my remarks for rebuttal. As the court can see, this is really not a very complicated appeal. The briefing is short and to the point. The appeal takes issue with the trial court's judgment entry in Wayne County granting summary judgment in favor of the defendant and determining as a matter of law that the conduct of the defendant, Mr. Mauger, was not reckless as a matter of law. We believe that factually and legally that is not the correct resolution, and now ask for this de novo review. The circumstances that happened are set forth in the briefing. Basically, it's a golf course case. Mr. Esposito was playing golf with his dad at Chippewa down there on 21 in Doylestown. Had a terrible circumstance whereby a golf ball from the 18th tee box, against all odds, flew right into the front of his golf cart and caused a very, very serious injury to a young man, resulting in the loss of his left testicle. The reason that this is reckless conduct is because it's acknowledged that the cart that the appellant and his father were sitting in were visible from the tee box, the 18th tee box. And moreover, that the state-of-the-art carts supplied by Chippewa have little icons on the screen that show the position of golf carts on adjoining holes. It's not something that you have to activate or turn on. It's just there. And so the testimony was that the appellant, the plaintiff, Mr. Esposito, with his dad, was about 170 yards out from the tee box. And this ball was hit to the right by Mr. Mauger. And I don't know if anybody's a golfer or knows the layout there of Chippewa, but it's not that far offline, and came right into his cart and caused the injury I described. The testimony was that the defendants and his foursome, he had a foursome, yelled "for," and it's also the testimony that it wasn't heard. This yelling "for" wasn't heard by Mr. Esposito, but that entire discussion is really just a courtesy in the game. Even non-golfers know that when you hit a ball offline, you yell "for," but as a matter of law, it doesn't in any way insulate or inoculate someone from recklessness, regardless of whether they yell "for." So that really is a non-issue. Whether they yelled it, whether it was heard, is not the issue. The court in Wayne County issued a 4 or 5 sentence decision dismissing the case. So we don't have a lot of insight as to what the analysis was, but the Ohio Supreme Court's case that also came out of Summit County, as it turns out, was a different situation than the one we have here. I'm now talking about the Thompson case, because the Thompson case concerned a shanked golf shot. And that word shank may mean nothing to a non-golfer. And so I actually put in one of the briefs, either the original or the reply, what a shank is. And basically, it's a shot that comes off the hosel rather than the face of the club. The hosel is the shaft that goes into the face itself. And the ball doesn't go 160 or 170 yards. Instead, it goes, for a right-handed player, it goes dead right, almost diagonally. And for a left-handed player, the opposite, it goes dead left. It's an unintended aberrational shot. And in the Thompson case, that was the situation there. This case is aligned with the Maxwell case out of this court, which was decided in 1998, 8 years after Thompson, in which a player hit a shot onto the green where the players ahead of them were visible, and it hit a player on the green on the same hole, causing injury. The only difference here is that Mr. Esposito was on an adjoining fairway, not on the green. But in that situation in Maxwell, it said that may give rise to satisfaction of recklessness. That is, and we all know the definition of recklessness, basically, a recognized harm, foreseeable harm, whereby the actions of the accused, of the defendant, create an unreasonable risk of harm.
Well, isn't that a major distinction, though, where in Maxwell, his shot is towards the green that they're playing, as opposed to in this case, where it sounds like it was a ball that was drifting due to the wind? I mean, that seems like a big distinction when you're talking about recklessness here.
Well, it's a difference. I'm not sure legally, though, it is a distinction, because shots to the left and shots to the right are well within the ambit of not only amateur players, but professional players. If you watch Sunday golf, as I do almost every weekend, you'll see the best players in the world hitting shots right and left, let alone, us amateurs out at Chippewa and wherever else we're at. So the point is, the question isn't whether it's on the green or on an adjoining fairway. It's well within the realm of a foreseeable consequence. When an amateur golfer goes to the tee, he might hit it to one side or to the other, may not hit it down the middle as his intended target. So that difference is no distinction whatsoever. In the Maxwell case, it just so happened that the player, hit the ball presumably where he intended to hit it, namely on the green. Here, I presume Mr. Mauger intended to hit it on his own fairway, but doesn't always happen. Whether or not, of course, the plaintiff in these kind of cases never files for summary judgment, as we didn't here. But it seems to me that this case would be more likely and more appropriately determined as a summary judgment for the plaintiff rather than the defendant. After all, the testimony is that they saw my clients sitting out on the adjoining fairway. The testimony is this is well within their range, how far they hit a ball. The testimony is they saw them there and hence yelled for, and didn't wait for them to clear out. And those are the elements that we saw in Maxwell. That is, the player that hit in Maxwell, it didn't hit a once-in-a-lifetime shot. It was a shot he normally hits within the range he hits. Just so happened somebody was putting out on the green rather than sitting in an adjoining fairway. So,
can you clarify for me? Did Mr. Mauger see Mr. Esposito's cart prior to hitting his shot? It seems to me that the other side is arguing that he did not notice that cart until after he hit his shot and the ball was in flight.
Yeah, fair enough. And I agree with you that that's a little bit vague. And I think if I understand the testimony, he's saying they didn't look over to the adjoining fairway because that's not where they intended to hit the ball. But once the ball was in flight and it's going toward Esposito's cart, they saw Esposito's cart. Esposito's cart didn't move. It sat there waiting on their fairway to hit a shot. So it's not as though it was ever invisible. It was always visible. It's just so happened that Mauger didn't actually look over there until that was the direction of his ball.
And counsel, you're just now coming up to that 5-minute mark. I apologize, Judge Carr. Go ahead.
Could I ask just one question? Was
Yes.
he wasn't the first to tee off though, was he?
Mauger?
Yes.
No, I don't believe he was the first to tee off, although the sequence as to who teed off first, second, third, and fourth in his group was not consistent.
But wouldn't it matter if he wasn't the first to tee off? How can you attribute recklessness to him and nothing happened with the other people that teed off? And we're going, and we're aiming obviously for the same hole and wanted to have their balls on the fairway as well. And obviously didn't hit the plaintiff.
Right. Nobody else hit the plaintiff. I'm not sure the question as to whether Mauger was reckless. It depends upon whether anybody else hit their ball toward Esposito.
Well, I'm just going from the standpoint that it's an unreasonable risk of harm. And is it unreasonable if 2 or 3 other people have already hit in the same direction? So they obviously assessed it and they either just decided they didn't care either that whether it was unreasonable or not, or it wasn't an unreasonable risk of harm.
Yeah, my answer is it's an unreasonable risk of harm for anybody to hit a tee ball or a fairway ball when another player is within their range, regardless of whether anybody else in their group did so. But there's no evidence that, go ahead, I'm sorry.
No, I said thank you. I don't want you to use up all your rebuttal time.
I'll stop now and reserve the rebuttal time.
Thank you. Counsel for the appellee.
Thank you. May it please the court and Attorney Breen. I'd like to begin by just addressing a couple of the issues that were raised by both Judge Teodosio and Judge Carr regarding the specific testimony in this case, because I think it's important. I think, obviously what we're looking at here is we start out by looking at what is a customary part of the game of golf and whether or not what in fact occurred in this situation is a customary part of the game of golf as opposed to reckless conduct, and the court rightly determined that it was not reckless conduct. And I think it's important to note that Mr. Esposito, appellant herein, his testimony with regard to what happened is important, and that is that he was on the 18th hole. He was playing a different hole than my client. He hit his tee shot into the rough and drove to hit his second shot from the spot where he ended up getting hit. He drove to that spot, and as he drove to that spot, he saw my client's foursome on the tee box. He chose to drive to that spot. He hit his second shot while they were on the tee box and then got back into his cart, all at which time he knew and recognized that there were people foursome hitting their tee shots.
Well, counsel, it sounds like you're describing an assumption of the risk type of argument on behalf of the plaintiff, but do we get there? As I read the trial court's one-line judgment entry, or just over one line, it says that this wasn't reckless conduct. So do we really get into assumption of the risk? Has the burden shifted, has the summary burden shifted to?
No, and I don't mean to argue that. My argument is directed to whether or not my client's conduct rises to the level of reckless misconduct, hitting his tee shot, intending it to stay on the 10th fairway, which is what all of the people on the tee box that day, I'm sure, intended their ball to stay on that fairway. And at the same time that he is making that determination to go ahead and hit his tee shot, Mr. Esposito has made a decision to drive into the rough and sit there and hit his second shot and then get back into his cart. And I say that because this was not within the range of the intended shot. This was a tee shot that was hit and ended up getting pushed right by the wind. It's something that happens in the game of golf, which explains why Mr. Esposito felt it was okay to go into the rough and hit his second shot, knowing that they were on the tee box. The Thompson opinion, and I think that the briefs there aren't that many authorities cited in the briefs. It's pretty basic and straightforward for the court's consideration, but the Thompson Supreme Court decision, I think, is applicable and very helpful in this case, and it goes beyond discussing a shanked shot. In that case, it was a shanked tee shot, or a second shot, I think it was. But the court discussed other situations in their determination when it said that not only is shanking the ball foreseeable and not an uncommon occurrence in the game of golf, but also the same is true of hooking, slicing, pushing, or pulling a golf shot. And that is exactly what happened in this case, pushing the golf shot, whether that be by something my client did in his swing or the wind, which everybody recognizes the wind was strong that day. In fact, Mr. Esposito cited the wind as the reason why he didn't hear the warnings from the golfers that day, my client and at least one of his foursome who yelled that.
You know, that's a custom, but the Thompson case said you also look to the rules of the game, and Attorney Breen has, at least in his brief, mentioned there's a rule that you don't tee off or hit when the players are in front of you and within the range. How do we deal with the conflict between custom and that rule?
I have two things to say with regard to that. First of all, that rule is not in the record. That citation came from the Maxwell versus Rowe opinion, which was a 1998 opinion. It was something that was cited apparently in that case's record. It's not in our record. I don't know whether that 1998 rule is still a rule. And what was mentioned is a rule of the USGA, which this is not a situation where the USGA rules are binding or applicable on recreational golfers out playing the game of golf. The other thing, that Maxwell versus Rowe case, which is where that rule came up, that was actually a high school golf tournament. I don't know, honestly, whether or not the high school teams apply the USGA rules of golf, but that was a situation where that was brought up. I don't think has any application to the court's consideration herein. The other thing I would say is,
I'm sorry, go ahead.
The other thing I would say with regard to that rule is that it says players ahead, and that was the situation in Maxwell versus Rowe. The reason why our case is distinguishable from Maxwell versus Rowe is that golfer was on the fairway of a ninth hole, and he hit his ball to the green of the 9th hole. So his ball went exactly where it was intended to go. And for that reason, the court decided at least a jury should look at the issue of recklessness as opposed to summary judgment. This is a very different situation. This is a situation like Thompson, where we've got an errant golf shot, something that happens a lot. And frankly, if we were establishing liability, anytime someone hit a bad golf shot, nobody'd be out playing golf.
Well, Counsel, you've made me think of another question too, but the first question was pertaining to Judge Teodosio's in regard to the rules of golf. And I have not read all the depositions or everything yet. However, I can't imagine that the individuals that were deposed weren't asked about whether you take a shot when someone is within your visibility.
I don't recall in the depositions that question was asked. Will say, and this was one of the things I wanted to bring up, I think that perhaps Judge Teodosio asked the question about what my client's testimony was with regard to this. And it was that, first of all, 2 of his foursome had already teed off. And second, that when he got up on the tee box, he did not see that golf cart. He actually thought the golf cart was moving when he finally saw it. It was not in where he was intending his ball to go in his view until he was following his ball. The wind took it to the right. And as he followed his ball, that's when he saw the golf cart and yelled 4.
In regard to that, what about the fact that now the golf carts have this mechanism so that you can know where all golf carts are at the time you're playing? That doesn't necessarily mean you'll know everybody that's in the woods or in the, wherever. But the point is, they didn't even look at that. They all admitted to that, right? They didn't even look at where the other golf carts were.
Well, they weren't in their golf carts at the time they were up on the tee box. And first of all, I don't think that that's something that should be considered a requirement of the game of golf. But second, golf carts are moving all the time. It would be impossible to get out of your golf cart, walk to the tee box, and not have a cart perhaps moving onto what would be on that screen. I have seen GPS in a golf cart, but I've never seen one that shows these icons. But again, if we were requiring those involved in this recreational activity to look at that GPS, they would have to sit in their golf cart and watch golf carts on adjoining holes and try to determine whether or not someone was going to hit an errant shot, which is exactly what Mr. Esposito did, and then drive into the rough. So there wasn't there was testimony about whether or not that technology was in the golf cart, and it was. But again, looking at it before they got out and went up to the tee box wouldn't have done them any good in this situation.
I understand your argument. I'm just not sure what's in the record regarding that.
Yeah, and I don't recall, other than that, Mr. Breen asked whether or not that technology was there, and I don't think there was any testimony that anyone looked at that screen at the appropriate, at the time when the tee shots were actually happening from out on the tee box.
And the cases, as you both indicate, there's not a lot of law in this area, but at the same rate, the law that we do have is prior to all this technology. What impact does that have?
Yeah, that's correct. It's 1998 is, I think, the most recent case that we've cited, which is the Maxwell versus Rowe case.
So my point is those cases wouldn't have had any of this technology so that golfers could be more cognizant of where other golfers are on the course.
And I'm sure that technology helps golfers be more cognizant in situations where they're in a golf cart, where that screen is visible to them. But this game and how the game is played requires them to get out of the golf cart and walk to the tee box, and some time passes. They may be up on the tee box waiting for the group ahead of them before they can even tee off. So requiring them to continuously look at that, I don't think it would be reasonable.
What circumstances would constitute recklessness? Can you give me an example?
Well, I think potentially what the court in Maxwell versus Roe ruled was, at least that was a question for the jury, and it was because that young man hit his shot into a green, which is exactly where he wanted it to go. That's where the person was, on the green or on the fringe of the green, and he got hit with the ball. Those of us who have played golf have probably had a situation where the group behind them hits into them and the ball lands close to them or even hits them. That potentially could be something to submit to a jury, but I mean, even in that situation, in my opinion, that's negligence, or perhaps negligence, not reckless. The court, I think it was in Thompson, suggested an example of recklessness would be a golfer who hits a bad shot, gets angry, and throws his club, and his club hits someone. That was in one of the cases that's cited as an example of reckless conduct.
I just have to laugh because I do golf, and that seems like that's a foreseeable consequence too. Somebody throwing their club.
I actually saw someone throw their whole bag into a lake once after a shot.
Better than a golf cart.
Was there any indication that Mr. Mauger's previous shots were affected by the wind to drift one way or the other? Yeah, I don't know what the weather was like that day. Is that going to be in the record?
That is not in the record. The only discussion of the wind is my client's indication that the ball was initially going straight and then the wind pushed it to the right. And the other discussion of wind is Mr. Esposito's testimony that it was a strong enough wind that it prevented him from hearing the warning. There's no other testimony regarding any shots being pushed by the wind.
So Esposito would have been hitting sort of into the opposite direction, right? Yeah.
Correct. These are,
So
yes.
So the wind, you would think, would have pushed his ball to the opposite side of his fairway.
Yeah, I don't know
Yeah.
anything about that other than that he did testify his ball went to the right as well.
All right, thank you.
And unless anyone has any additional questions, I'm finished. Thank you very much.
Seeing none, thank you. Mr. Bream, you have 3 minutes and 40 seconds remaining for rebuttal.
Okay, thank you. The discussion about the icons, it's at page it's at page 2 of the principal brief of appellant. Each of the 4 golfers acknowledged that they knew that the icons depicted the adjoining carts. Each of the 4 golfers said they never looked at it. Of course, when you, and just to be clear, they were playing the 18th hole, not the 10th hole. I know that Ms. Weiss knows that, but that got a little bit. They were playing the 8th hole. Mr. Esposito was playing the 10th hole. So when they pulled up to the tee box on the 18th hole, those icons were there. And of course, you have to walk to the tee box to actually hit your shot. That's true of not only their foursome, but everybody's group that plays the hole. If they weren't intended to let the golfers know when they pulled up where the carts are, then it would serve no purpose if you required that they also have access to that when they're hitting the ball. It doesn't make any sense. I guess secondly, it's not true, and there's no evidence that the rules of golf only pertain to high school golfers. The USGA rules are cited by this court in its prior decision. And as a relevant consideration on recklessness, that is, you're not to hit the ball into when other players are within your range.
But is that part of the record in this case?
Once again, please.
Is that within the record of this case, the rule?
First off, there was no trial, so there really isn't much of a record. There was depositions. And so, but the rules of golf existed just as the law existed, just as the Ninth District Court of Appeals decision existed at the time of this case. I'm now talking about your decision in
Maxwell.
Maxwell. Thank you. But at the deposition, the rules, the book itself wasn't discussed, but it still applies because Maxwell says it applies. Had there been a trial, there doubtlessly would have been the rules brought out. The circumstances remain that this is hitting a ball into somebody else's, into an area where you know it's within your range. It's different than a shank, which is a completely unintended shot. This is an intended shot, not necessarily direction-wise, but range-wise. Judge Carr is a golfer. Judge Carr understands that while there's always wind out there, what really moves the ball from right to left is the spin on the ball. It's accentuated by wind, but it doesn't make it go. It's not the Wizard of Oz. It just moves it a little more dramatically, but it's the spin that the player imparts on the ball that moves it.
And counsel, I unfortunately need to inform you that you have utilized your rebuttal time today.
I'm sorry. I'm finished.
Okay.
Okay.
You.
Thank you so much.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which is mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Thank you both for your arguments today. Have a wonderful day.